Yeah. Okay. Good evening, ladies and gentlemen. Welcome to the special meeting of the Lincoln Park City Council. Today is Tuesday, the 29th of April. The hour is 6 o'clock. We are here for the one purpose only, and that is to discuss the Eric Williams report. That being said, I will entertain some opening statements from Mr. Williams on his report. Then we will make our way around the table for council people to ask questions. And we're going to begin with a roll call.
Councilpersons Brady. Here. DeSanto. Here. McPartland.
Here.
Murphy.
Here.
Myers.
Here.
Mayor Baslow.
Here.
Mayor, thank you.
Mr. Williams, if you'd like to begin.
I'm ready.
Thank you.
Thank you for the opportunity to be here. And I see there's a lot of folks from the general public here as well. It's always a good sign in local government when people are interested in its operations and what is being accomplished. In this particular situation, when you asked for my legal review of what took place, there were some good things to look at and there were some things that weren't so good or that were a bit disappointing. And I attempted to outline those, and I'll summarize it for you, and then obviously there are a lot of questions, I'm sure, and we can take them in whatever order will work best for you folks. Clearly you had a lawsuit that was settled, and then the terms of the settlement created controversy for the community and for the council. When you analyze, or when I analyzed the lawsuit, it was clear to me that the result and the outcome was favorable to the city of Lincoln Park. I have to say that with a bit of an asterisk or a caveat, though, because in any of these kinds of lawsuits involving the adult entertainment businesses, whether they be the porn shops, the adult cabarets, the topless bars, whatever form it might take, any community that's involved in the incursion of those businesses into the community reacts with some dismay that their town will now host or be the site of one or more of those businesses. And that's common, and it is to be expected. Within the legal arena, though, local government must operate within the parameters of our Constitution and our state laws. And there are some businesses and uses that, while they may be unpopular to some, or maybe to many, still have a right to do business in a community. And the regulatory framework that's at your disposal as a municipality to regulate adult uses is broad and wide-ranging, but limited. It is very specifically limited as to its effect. And that is a general constraint against which we work. It's not helped, quite honestly, by the fact that the United States Supreme Court, when called upon to act on businesses featuring nudity, has split over the years in its opinions, generally indicating that local government and state government should be allowed and capable of regulating nudity, but there is no clear template by which local governments can do this with some clear prior stamp of approval. And what that means, as a practical matter, is municipalities like Lincoln Park and across the country wrestle with the general issue of regulating adult businesses every day, every week, every month, and every year. And whether it's one lawsuit like the one you folks were just involved in, or another lawsuit like the one I hear perhaps is being filed and served right now, whether it's one lawsuit or another, the issue of the adult business regulation by municipalities goes on. It doesn't begin with a particular lawsuit, and it doesn't end with a particular lawsuit. Because regardless of the outcome in one particular lawsuit, you still have the businesses, and you still have the need to regulate, you still have the need to monitor, you still have the need to evaluate your ordinances, and you have the need to adopt them and modify them in a way that makes them work. It is disappointing to have an ordinance invalidated, whether by court rule or by settlement, but it doesn't mean that the municipal role ends. at the time of that settlement or adverse court ruling. If every adverse court ruling across the country meant that municipalities had to stop regulating, you'd be out of the business of doing it right now. And that's not the case. It's a constant learning curve for us. Some communities prefer to be on the cutting edge of that regulatory framework, and some prefer not to. That's a matter of setting your own priorities about how much you want to invest in a regulatory effort, both research, adoption of different ones, enforcement of them, litigating them. It goes on and on and on. And against that backdrop, I want to commend you for taking the time on this difficult lawsuit to look at it and look at it carefully and raise those questions. If you thought there was something wrong with the settlement, I think it's fair game to say, you know what? Somebody thinks there's something wrong or somebody has questions. Please look and tell us if it's okay, or if we gave away the farm, or it's a complete unmitigated disaster. I don't think Lincoln Park gave away the farm. I don't think it's a complete unmitigated disaster. I think there are some positives. The closure of the Park Theater is a positive. The restrictions on that site, preventing it from going into an adult business use, again, is a positive. The new business, perhaps unfortunately named the Hustler Club, maybe fortunately, but it has some connotations that I think don't sit well for a community. But nonetheless, the new club that's proposed, that was the subject of the litigation, is proposed to be an adult business with a liquor license, which means it's largely regulated by the LCC, and the local ordinance regulations almost take a back seat to the frontline regulations on a bar. Typically, what's generally viewed as the topless bar type business in Michigan is not that heavily regulated by most of the host municipalities, because the LCC takes the driver's seat role in regulating. The business, which was the subject of the lawsuit that has you folks obviously concerned with what happened and what will happen, is proposed as a bar that will apply for and obtain a liquor license with topless entertainment permit. In the adult business regulatory scheme of things, that type of business, as compared with the fully nude adult cabaret, is a notch below the fully nude adult cabaret type business in terms of the regulatory needs of the local municipality. It's also a notch below the corresponding negative secondary effects and the associated criminal activity that can be found and is frequently found with the true adult cabarets, I should say true adult cabarets, complete adult cabarets that feature the totally nude performances and don't have the liquor license. Michigan doesn't let you put the two together. They're separate. So it's important to remember, and it was a key part of my analysis in this case, that the City of Lincoln Park, by way of this lawsuit and settlement, did not give any sort of approval to the fully nude performances, which is on the high end of the spectrum of the ones that a municipality needs and wants to regulate. Those are the businesses that experience has shown are real regulatory nightmares. They require more police activity and vigilance and monitoring than the topless bars or the bars with the topless entertainment permit. So against that sort of backdrop or landscape, when I analyzed your particular case, Lincoln Park's case, one of the things I noticed right off the bat was the type of use that was proposed was not the totally nude performances. And there's nothing in the lawsuit or the settlement that somehow permits in advance the totally nude performances. It's just not there. Had it been there, I may have taken a different view of the whole settlement package, but it simply is not. And I wasn't even sure for the City Council and for the members of the public that have heard about the lawsuit if they realized the difference between that type of use and that level of regulation and the role of the municipality. So if there had been a suspicion or a belief that this lawsuit or this business involved the totally new performances that had somehow been permitted through a lawsuit by the City of Lincoln Park, that's just wrong. That's not what happened. There are some provisions in the judgment that I find a bit problematic that I think, in fairness to you folks, I need to talk about a little bit. I don't see them as affecting the overall opinion, and I didn't elaborate on them in the written opinion, but I think they're there, and for the long term, I think you need to know about them, and I think there's some provisions that you may end up having to revisit. And I'd like to address those, but before I go there, which is kind of outside the scope of the written opinion, I guess I would like to invite, or have the mayor invite, questions from council members, whatever's at the top of the list, or at the forefront, or complaints or criticisms. I'm open for all of them. I understand the topic is controversial, and I'm accustomed to dealing with difficult or controversial questions on it, so I'm ready when you folks are.
Thank you, Mr. Williams. We'll begin with Councilwoman Brady.
Thank you very much. Mr. Williams, I do have to say I very much, and you know I've sent you an email telling you this, we very, very much appreciate your help. You helped us before with the initial opinion and gave us some direction then, and here today, you've always been a big
Thanks.
help.
I'll try some more.
Thanks. So hopefully you don't have to.
We'll
but
have
I have a couple of things. I have a long list, a hit list, but one of the items that, and I'm going to do it while it's fresh in my mind, that you had just mentioned was the partial nudity versus full nudity.
Yes.
And the negative secondary effects are higher at full nudity establishments?
Yes.
Okay. But where do you think, what type of establishments do you think are more profitable? Ones with a liquor license or without?
I don't have any data that I can cite. I can tell you from my communications with the people in the businesses when they're trying to get these going, and I happen to be on the side of the municipalities, with just like the lawsuit you folks are finishing up with. What I hear from them is they either have to have the liquor license and try and make it some kind of an upscale liquor sale business with the topless entertainment to get the people in, and they make their money off the sale of the liquor, or they have to be the totally nude establishments in a location where they think they can get people in without being fearful of the surrounding crime. So it can be either one if they can design the business correctly. And what I hear about the totally nude businesses is if a municipality enacts the scantily clothed or G-string type regulation, that it sharply cuts back the profitability of the business to the point they become marginal. And I think part of the language in the consent judgment and settlement that would be a bit problematic down the line that I didn't have in the written opinion, because it kind of goes out into the details pretty far, comes from the same kind of question you're asking. Because there's a suggestion in the settlement and judgment that Lincoln Park cannot enact another ordinance or any other ordinance that would further regulate the adult businesses. It's a little amorphous, but that's the gist of it. And there may be a need at some point that Lincoln Park to consider adoption of an ordinance that would do something like require the G-string or a minimum amount of clothing in what would otherwise be the totally new performances. And there's an open question in my mind as to whether or not the terms of that consent judgment settlement agreement would preclude the adoption of that ordinance on its face. I have a couple more thoughts about that. Number one is I'm not sure that's enforceable against the City of Lincoln Park. Number two, the way that consent judgment and settlement agreement is written, if that regulatory issue became a primary objective of the City of Lincoln Park, if after research, deliberation, and consideration, this City Council said, you know what, that's where we really think we need to go, then I would recommend reopening the settlement agreement, not by going to court to challenge it, by reopening it with the opposition here saying, here's what Lincoln Park wants to regulate. We don't think it affects your business. We want to go there. We want to make sure that you folks aren't going to somehow assert that this particular ordinance is somehow violative of that settlement agreement and judgment, so you could still get to that regulatory point. And that's kind of far out on a limb, but it was part of where I went with the analysis of perhaps wanting to do something in the future. Some of that language I think is a bit problematic in the consent judgment settlement agreement on that type of term because of the possible need to consider and adopt an ordinance like what I just described for you.
And that was my question. Because if I say that there are associated negative secondary effects with adult use businesses, that would be a factual statement according to your knowledge, would it not?
Sure.
And that we, as a council, have an obligation to regulate the crime in our city. I mean,
yes.
So, with that being said, what options do we have? That was one of my big questions for you tonight, is what options do we have left?
And that's probably a $64,000 question. And one of the options would be to, in general terms, follow what I would call the Grand Rapids model at the moment.
The Grand Rapids versus Sensations case?
Yes, and related litigation. It's still in the Sixth Circuit. Grand Rapids did a little different regulatory approach, essentially saying we're not going to ban nudity per se, which is the ordinance you folks had, similar one, and the one that Southgate had and lost. Grand Rapids took a little different approach and said we're not going to ban nudity, we're going to say you have to wear a minimum amount of clothing, a very minimum amount, or minimal amount, and therefore it's not a complete ban.
Right.
That regulation so far has survived the court challenge in Grand Rapids, but it's a few years into it, and it isn't over. And I couldn't tell you the amount of money expended, but it's easily in the six figures. So that would be a regulatory option still. It seems to me when we were here before, we talked a little bit about, or when I was here before, we talked a little bit about a regulatory initiative where you would have the ban on total nudity and enforce it against one of the existing businesses. And there was a question as to how long that court battle would take and how much it would cost and how productive it would be. And I never heard that there was any formal decision about how to do that, but I think, from what I can see, that you didn't launch a regulatory effort in trying to close the one existing business with that public nudity ordinance. That means if you want to identify an objective of adopting another ordinance trying to limit or restrict the new performances, you can still do it. The cost, the likelihood of success is always open to some debate. But you can still do it. It's a matter of identifying priorities, how important that one or type of business really is in the community in terms of putting an end to it, how much you want to spend on it, and the risk of perhaps winning or losing in the court battle. Right now, Grand Rapids is still winning in theirs. Let's go back a few years. If you had asked me, Eric, is Lincoln Park the city in the state that ought to launch this battle, enact that ordinance, and try and enforce it, I would have probably recommended that you should not be. Grand Rapids is probably just a little better situated to take up that battle, and they have. And that's where municipalities have to learn from the experience of others instead of each trying to litigate their own major case on a point like this one. You're better off having one city that has the resource to handle it, do it, see how that one goes, and then perhaps follow suit rather than trying to develop your own from scratch.
And Mr. Williams, we did something similar to that after our last discussion with you with our adult cabaret, because it is my understanding that licensing procedure has withheld court challenges, and ours probably was pretty sound. We've we've had several attorneys tell us that was a pretty sound licensing procedure to regulate.
I concur.
And my issue with that is being that we took the action to regulate the negative secondary effects. For the most part, that licensing procedure is no longer going to be a workable means to regulate the crime in this city. Of adult use, it matters.
I think you still have it.
Well,
it's not gone completely.
Well, I mean, I want to show you something.
But there are some pieces out of it now.
Yeah. You know what? I did this because it just. And I'm going to show you kind of like I don't have the easel, but yeah. If you look at, and I've kind of outlined it because sometimes a visual makes a big difference. The green items here are just procedural things that says, you know, it just gives our definitions, the chapters, and so on. Everything in yellow is gone. Everything in orange is modified. So, I mean, I'm going to show everybody in the audience, and you can see the green items are procedural, really don't mean a lot other than a definition, effective partial invalidity, you know, it's just technical language we have to use. The yellow, again, are items that are no longer useful for settlement agreement. The orange ones are modified procedure.
Val, or Ms. Brady, while you have it up, can you point to the AB one, let's see, it's the one that says, it'll be the one that's stricken, and it's the on the stage and 60 inches from the patron. Can you point to that one?
Yes, let me find it in here. That's an additional.
At 80814 AB, I think.
Yes, right here down the bottom.
Okay.
Which is stricken also.
And in my own, I went through it line by line, looking at which ones were stricken and taken out. That's the one that I think is a significant loss to the city in terms of regulatory impact.
I think you're exactly right. And I proposed some language, and we'll get to that too. I want to talk to you about that also, but there was some additional language I wanted to talk to you about regarding that. But if we go back to the yellow items being gone, the green items being just regular general items, and then the orange being modified, you kind of get a clear picture of how much and what's left. Really, what's left?
Well, they still have to get their license. You still have some measure of requiring them to come in and do that.
Just the business itself has
True.
to get their license, not any
True.
of their.
Not the entertainers.
Right. And you know, and what really gets me about this part is even when we say, okay, we left this part with just a couple items restricted, which is the revocation of their license, they did one up on us. This part's fairly untouched. 4 items are gone. But they outsmarted us, and they said, well, we know you got it on the book somewhere else, so it's gone here. So that invalidates the other
one.
part.
Is that the one where the
That
clerk
is 802, licensing in general. So now that part is gone in its entirety. So that there's nothing left of that. I mean, I thought we took a pretty sound measure in regulating with that licensing procedure, and it's probably been one of the most effective measures to control the crime that I've seen, and it's gone.
All I can say is that that's a loss to the city. There isn't any other way to put it. I don't know how effective the use of it has been against the existing business that has the totally new performances. I don't know how much they've registered, how much they've been inspected, how often they've applied for and gotten a license. I don't know that. If you folks, meaning the city, have been enforcing that ordinance against them strictly and they've been following it, all I can say is good, keep doing it.
And they have. And they have been. And they have been. And I posed the question to you. My question was if they decide, well, we don't like that anymore, we don't want to have to do that anymore, and they can test that, where are we going to stand with a court challenge?
I would still resist it. This particular consent judgment says right in it has no res judicata effect between these parties, and it doesn't mean anything as to another party. So they would have to, if they want to bring a challenge to that particular ordinance, they're going to have to bring it on the merits, and they're going to have to beat you. It's not a slam dunk for them.
No, but you know what? I did send over a couple moratoriums and a resolution, kind of a change in language for the prostitution and fornication ordinance we have on the books. And I want to touch base with you on that, simply because obviously we need to, with the only regulation we had in place being gone, I mean, our adult cabaret is gone, we do need to take some kind of measures to regulate the crime. I don't think it's very responsible of us to take those measures after the fact. We need to be a little proactive with this.
And I don't disagree with being proactive. If there is a crime pattern associated with one or more particular businesses, then I usually ask to figure out or have somebody show us what that crime pattern is, and then develop whatever ordinance regulation you think fits that addresses that particular issue. And I'm not sure what crime pattern you have that you're talking about that you want to address.
Well, I want to ask you, first of all, about hotels or motels being in close proximity to an adult business and short-term hourly rates, rental rates of those hotels and motels, because I've read some stuff with it from the DOJ and so on regarding how they promote prostitution. And
they can. The pattern that I hear about or read about and have heard about is where you have some sort of an adult business, usually featuring the live, totally nude performances, and you have an adjacent motel or hotel, and the adjacent motel or hotel offers rooms by the hour or 2 hours, and promotes that. And the people seem to go from the adult business to the motel.
Which we have that now. We have that going on now.
Is there a pattern like that in Lincoln Park?
Yes.
Yes.
For one business, the one that has the cabaret license.
Is the connection the motel that's located immediately
There's actually,
adjacent?
well, there's actually two. Yeah, that one, of course, yes, but there's actually two others very close to that also doing the same thing that I've been hearing quite a bit about.
Okay. I wasn't aware of that fact pattern. When I went and looked to refresh my memory as to locations in your community, I couldn't help but notice by I guess it's the one lounge, is there's some kind of a motel, it looks like, immediately adjacent, which would lend itself to that type of activity if it is going on. If you have that actual problem in your community, in other words, a motel immediately adjacent to an adult business, and the motel is renting rooms by the hour, and neighbors or people in the community notice there's a problem with it, or there's criminal activity associated with that 1 hour room rental, then that would call upon the city to regulate that type of behavior.
Would you
Prohibit it or extend the time frame. In doing, if that's going on, and I don't doubt you, it's just sort of as a
right.
premises, if that's going on, then I would suggest that the city take a proactive step in talking to the motel and hotel operators and owners in the community and saying, look, if there is a problem like this and the city wants to embark on regulating or prohibiting 1 hour type rentals or room rentals, we want your input first and involve you in it, and then here's where we're going to go and here's why. And you may get from them, that business community, especially the folks that want to run a good business, some good ideas as to how that regulation can be drafted to fit your community. And then somewhat along the lines of what I guess you had proposed or you had come up with, that might very well be a good regulatory approach for that particular activity.
I seen a neighboring city did something with the short-term rentals. What they did was they required them to license themselves as an adult business if they were going to do short-term hourly rentals. I'm asking. I'm asking what you think about it.
Yeah, I would want to look at that one and think about it. I suspect if you take a deliberate and measured approach toward the regulatory issue, you're going to hear from the hotel and motel people what they think would work and what wouldn't. And you may hear from some people from your community that whatever activities are going on in the motel room, it's certainly preferable to having those on the street. And so you may get a little mix of opinion as to whether that regulation is what people really want.
What do you mean about on the street, Mr. Williams?
Well, if what you end up with is if you have criminal activity associated with adult business in a local motel or a nearby motel, it probably will involve some form of prostitution or sexual activity out on the street or for hire. And you just may get a mixed reaction to the idea of we don't want the motels rented that way.
That leads into my other question to you. My other recommendation was to prohibit creating secluded areas or structures that encourage prostitution and street prostitution. And this is why I'm asking you this, because this was my logic behind exactly what you're saying. First of all, we need to regulate the prostitution with the hourly rentals, and then you need to take an action towards street prostitution. So you're hitting both. And I had Mr. Duchesne send them over to you. Did you have a chance to look at them?
I looked at the motel one, and I think I glanced at the other one, but I don't remember that one in the details. I looked at the room rental one with some care. The other one, I did not understand how that fit in, and I didn't study that as closely.
Okay. I would really like you to take a look at that if council doesn't mind. I would like an opinion on it.
I'd be happy to. It helps a lot hearing from you what the fact pattern is that the city would be seeking to address. Because when I got those materials, I checked with the city attorney and the city manager who said, do you have the 1 hour rental problem? Do you have complaints of prostitution and the motels turning over the 1 hour rentals? I was told no. So there's obviously you know more about it than what I had heard from the city attorney and city manager, which means that there's more here to work on than what I understood was there. And that helps, though. If you have a fact pattern, then you can tailor your ordinance to fit it rather than just enacting one to enact it.
Right.
From what you have said about what you have for a problem, you are on the right track.
Yes, and we do have a problem there. And I'm also concerned with the new proposed site being on the border of Detroit and Melvindale, with urban sprawl. And I think some of that's going to come over, and I do not want the prostitutes thinking this is a good place to be walking the streets, or a hotel coming up right next to or near to the existing club, exasperating the problem there.
Well, the obviously prostitution isn't a new thing, but it is a recognized negative secondary effect of adult businesses. It tends to cluster around those adult businesses. But I think that's a more general police regulatory approach to things. I mean, if there's a problem with soliciting for prostitution in a community around a business, it calls for greater police work in that vicinity. There's no special ordinance to prohibit prostitution that's proved to be particularly effective.
If that location or any adult use location in the city requires more police protection or personnel, is there any way that we can go back and bill them for those services?
Not appropriately. I mean, it is talked about, it's been discussed. I'm not sure it's actually been tried. I've heard the discussion numerous times in municipalities looking at and asking those questions, and then where that analysis tends to go is if you look at your calls and your record of police calls, you'll probably find that a local church or Legion Hall that was going out for wedding receptions had more calls than one of your adult businesses over the course of 6 months or a year. And then people say, well, are we going to bill them too? And the focus of trying to bill for those police services tends to get misdirected, or it's hard to support it. But what you can do is if you see that there's more police or emergency service